Hello everyone. So in today's video I'm going to talk about principles of natural justice. Now we'll discuss its origin, how it's enshrined in our constitution and some of its limitation very broadly. This topic is more important for mains, the origin of these principles. So the term principles of natural justice has been derived from the expression jus naturale, which means natural rights. These rights are based on the system that something is either fundamentally wrong or fundamentally right. For example, stealing is fundamentally wrong. Nowhere in the world someone would say that stealing is good. Similarly, helping someone in need is good. No one is going to say don't help others. Okay. Now, these principles are also known as common sense justice. Now, common sense is practical knowledge, right? For example, if you're hungry, you eat food. That's a common knowledge. For example, you do not cut the branch of the tree on which you're sitting on, as Kalidas has been accused of doing, because that's against common knowledge. You'll fall down. Now, of course, when it comes to judiciary, it's not going to be as simple because lawyers make things complex. So we'll see how principles of natural justice relate to common sense justice. And finally, these principles, they may not be part of a law. That is, a law may not explicitly say that the principles of natural justice have been incorporated in them. However, they are necessary to be followed to ensure justice. That is, these principles are essential for delivery of justice. Now, how these are essential, we are going to discuss that part in this video. Even the Supreme Court of India has eventually incorporated these provisions in many articles of the Constitution by virtue of this argument only, that these principles are necessary to ensure justice. Coming to the components of the principle of natural justice. So there are three components. The first two were derived from the Roman times, while the third one is a modern addition. The first principle says audi alterum partem, which means hear the other party. Now, of course, say you have been accused of a crime. If you're not given the opportunity to present your case, how will you ever defend yourself? What if you have been falsely accused of that crime? Justice won't be done towards you. Thus, it is necessary that you are given the opportunity to be heard for the delivery of justice. Okay, so the first principle ensures that justice is done. Similarly, the second principle, nemo judex in causa sua, it means rule against bias. In other terms, it means that no person should be the judge of their own case. Or in a broader term, a person who has some interest in that decision should not be a part of that panel who decides what is to be done. Okay, like recently you must have read that the CJI of when the sexual harassment charge was framed against the Chief Justice of India, Justice Nariman recused himself from that panel because he said he's close to the Chief Justice and it might lead to bias. Okay. Similarly, if say I have stolen something or I've done a crime and I'm the one who's adjudicating that case, I'm not giving a decision against myself. My self-preservation instincts will kick in. Similarly, like say you're entering a competition, you're one of the participants and you're one of the judges, you are going to give some benefit to yourself. It's only human to do that. So the principle says to ensure justice, one shouldn't be the judge in their own case, or one shouldn't be personally, emotionally attached to the case. Now, the third, the modern one, is reasoned decision, which means reason must be given out, a detailed reason must be given out for any decision that has been taken. And that is why you see Supreme Court has some huge judgments, like the Aadhaar case judgment was 1500 plus pages. The recent reservation case judgment was again 900 pages. The reason for this is They are writing every argument and counter argument and opinion put forward by the petitioner, by the counselor, and even by the judges who are hearing the case. This ensures that a process has been laid out, chain of thought for coming to the decision is out there for everyone to see, to accept that yes, justice has been done. So that's how these three principles are the component of the principles of natural justice. They help ensure that justice has been done. Coming to how natural justice is enshrined in our constitution. Oh, they have not been mentioned explicitly anywhere in the constitution. Nowhere there's an article talking about the principles of natural justice are part of the Indian constitution, part of our judiciary or anything. However, the Supreme Court, through various judgments, have found that these principles are indeed incorporated in our constitution under various articles. Okay. Now, we'll discuss these how these principles are incorporated in our constitution in detail, but like just for an overview, Article 14, which talks about right to equality, right against arbitrary action of state. Article 21 talks about life and liberty, that it cannot be taken away without a procedure established by law. Article 22 deals with that a person must be informed of the ground of arrest. They must be produced to a judicial magistrate, except in some cases related to preventive detention. Article 32 and 226 deals with enforcement of rights. So 32 deals with enforcement of fundamental rights specifically. 226 deals with enforcement of all the rights. So these four of them are more related to the fundamental rights section, that is part 3 of the Constitution. Article 39A has provision for free legal aid. This is a TPSP. And Article 311 deals with all India services, grants certain protection to the civil servants. So coming to the evolution of these principles in our constitution. First of all, we'll talk about Article 14 and the Supreme Court in various decisions, cases such as A.K. Kripak, Menka Gandhi, DTC versus DTC Congress, held that right to be heard is guaranteed under Article 14. It went on to say it is in essence it enforces equality. Now how does it enforce equality? Say state has taken an action against you, be it administrative, be it quasi-judicial, or be it judicial. Now, if the action has been taken against you and you are not given an opportunity to defend yourself, to present your own case, it amounts to inequality, as only one party, which is, formulating the charges against you, is the party that is being heard. Okay, so you and that party are not on the similar footing. You both are at a separate footing. One has been given the chance to present its case, while you are not given a chance to defend your case. And thus it violates the principle of equality. Not only that, it might also lead to some arbitrary action on the part of state, because you are not given the chance to present your case. No one knows what happened exactly. Only one side of the argument is being given. The other side has been completely left out. That goes against Article 14, and thus the court held that right to be heard is guaranteed under Article 14. Now, in the Menka Gandhi case, the Supreme Court went on to say that yes, the principle of natural justice are contained in Article 14 by the virtue of right to be heard. Now, in Menka Gandhi case, the court also said that in Article 21, the term law does not only mean procedure established by law. It does not only guarantee protection against arbitrary action of state. It suggested that the term law means due process of law. That means that the law should be fair, it should be reasonable, it shouldn't be arbitrary. Like legislature can't make an arbitrary law. Thus, maintaining that our constitution has the concept of procedural due process. And procedural due process or due process of law is a fundamental principle of natural justice, as it ensures that the action the action by any organ of state is not arbitrary. This is how principle of natural justice is contained in Article 21 of our Constitution. So apart from Article 14 and 21, Article 22 has direct implications of principle of natural justice, as it talks about that a person must be informed of their ground of arrest. Not only that, the said person must also be produced to a judicial magistrate within 24 hours, thus giving them an opportunity to be heard. So the first part, that the person is informed of their ground of arrest, ensures that when they are being given the opportunity to be heard, they can present their case against the charges laid down by the state. Thus both this part together imply that principle of natural justice is upheld. Now similarly, Article 39A, which deals with free legal aid to people who cannot afford it, it ensures that a person, even though they have no understanding of law, even if they don't even know if there's a said law that has been violated by them, they are given the opportunity to be heard. They can present their case. Now, of course, not everyone can present their own case. Not everyone is a master of law. And especially in a country where the literacy rate is still not even close to 100%, people must be given free legal aid to ensure that they have the opportunity to present their case and ensure that justice is being done to them. Thus, Article 39A also ensures that opportunity to be heard is given to everyone irrespective of their economic standard. Now, Article 311, which talks about protection given to civil servant, has the provision that no civil servant can be removed, reduced in rank, or dismissed without being informed of the ground of the charges against them. It further mentions that they are given the opportunity to be heard. So, like in Article 22, it again ensures that the civil servant is informed why a decision is being taken against them, what are the grounds for that decision, as well as they are given opportunity to present their case to defend themselves against such an action. Similarly, Article 32 and 226, which deals with enforcement of fundamental right and rights in general, respectively, also ensures that everyone has the opportunity to be heard when their rights are being violated. Thus, all these 4 or 5 articles, they ensure that a person must be given the opportunity to be heard, to present their case, to ensure that justice is being delivered to them. Coming to the third principle, that is reasoned decision, it is a modern addition. It has been added because of its importance. We'll see how. So the code first of all held that records of reason must be maintained for any administrative action as it is maintained for a judicial or quasi-judicial actions. Okay, we have already talked about how Supreme Court, like how court gives very detailed judgments. So what these detailed judgments do is they explain what was the reasoning behind coming to that decision. And when this reasoning has been told to the public, has been conveyed to the general public, it entails that justice is not only done but is also seen to be done. Now, this is an important point, that justice should be seen to be done. Okay, this ensures that there's faith in judiciary, there's faith in the administration, there's faith in executive on behalf of citizen. Okay, it ensures that the action is not arbitrary because citizens know that yes, these were the reasons that the said decisions has been taken. Now this reasoning also enables the provision of judicial review because the court can then inquire into each and every minute details of a decision based on the chain of thought and reasoning provided. It enables openness. As you all know, openness leads to good governance, and good governance is a part of welfare state, which is one of the objectives as entailed in the preamble of the Constitution. It also protects against any arbitrary action of the state, because once reasons has been specified for any action, if the reason is arbitrary, it's easier to know. Okay, and the person can again approach the court and a review of those orders can be taken. Thus, it ensures that Article 14 is not violated, and hence, due to these factors, it was held that reasoned decision is important to ensure that justice is being delivered. From the previous discussion, we can thus come to the conclusion that the aim of these principles are only to secure justice or to prevent miscarriage of justice, as they ensure that both parties are given an opportunity to be heard, that the adjudicating person is not biased, and a detailed reasoning has been provided for whatever decision has been taken. Further, these principles, they do not supplant the law of land, but they only supplement it. What it means that principle of natural justice by itself, they cannot replace the law of land. Law of land is above these principles. What these principles do is they supplement it. They supplement it by ensuring that these laws are fair. These laws result in fair treatment of every person. Further, it is clear from the discussion that the principle of natural justice are also applicable to administrative action, and they are not only limited to judicial or quasi-judicial action. As like if you relate it to Article 14 of the Constitution, administrative action is also included in Article 14, and since Article 14 talks about right to be heard, thus these principles indirectly apply to administrative actions of state as well. Coming to the limitations on these principles, the Apex Court has clearly stated that these principles are not part of the fundamental rights. That means that they are not guaranteed the similar level of protection that the fundamental rights are guaranteed in our Constitution. Despite that, the principles of natural justice have their significance in delivery to justice. The second limitation is imposed by Article 22 by stating that in matters related to national security, preventive detention is allowed, and the person can be held in custody for 3 months without being produced to a judicial magistrate. That is, it is denying the opportunity to be heard. Similarly, Article 311 states that if conviction of a civil servant is based on criminal charges, or if it is not practical to hold an inquiry, or if the case pertains to security of the state, the civil servant may be denied the opportunity to be heard, or they may also be denied to be informed on the grounds of their removal or reduction in rank. Thus, in the Menka Gandhi case, the court held that matters related to anti-smuggling, public interest, security of state, or if cases where prompt action is needed, these principles can be foregone. And finally, legislative action is not subject to principles of natural justice, provided that such a legislative action is done by a competent legislature. So, for example, members of parliament, they determine their own salary. Now, one cannot complain about this that it violates the principle of natural justice, because it is assumed that since they have been elected by the people of this country, they are responsible. So we give them enough faith. Now, similarly, if a legislature decides the capping of prices of drugs, it is the legislature's prerogative, and the court cannot inquire into the matter. The court will only inquire if the matter has some malified intention. Thus, we can see that there are limitations to the principle of natural justice, and they are not absolute. To summarize, these principles are derived from the Roman law, and they have been held to be essential to ensure justice. There are 3 principles. The first one is hear the other party, the second is rule against bias, and the third is reasoned decisions. They have all been explained in quite detail. These principles are not explicitly mentioned to be part of our Constitution. That is, nowhere the Constitution says that principles of natural justice is part of our Indian Constitution. However, the Supreme Court, through various judgments, have incorporated the individual components under various articles as you have already seen with Article 14 and 21. Apart from that, Article 22, Article 311, Article 39A also contains some components of natural justice. And finally, there are certain limitations on them. Some have been explicitly given under Article 22 or 311, and the others are implied in nature, such as in the public interest, national security, and for matters related to legislature. That is it. Thank you, everyone. Have a good day.